Ready, start. He urged that the cases instituted by the respondent against the appellant and his family members are a clear reflection of her vindictive nature and are nothing short of a gross abuse of the process of law. Full stop. Learned counsel urged that the appellant gave a generous proposal of permanent alimony to the respondent for an amicable settlement of all the disputes, but since she has the propensity to continue the harassment and humiliation of the appellant and his family members, the respondent has bluntly repelled this genuine offer of settlement made by the appellant. Full stop. She has also countered all efforts to settle the disputes despite multiple mediation efforts. Full stop. On these grounds, learned senior counsel representing the appellant urged that this is a fit case wherein this court should feel persuaded to step in to end the plight of the appellant and his family members by exercising the powers conferred by Article 142 of the Constitution of India. Full stop. He prayed that while quashing the proceedings of the various cases filed by the respondent against the appellant and his family members, a direction deserves to be issued dissolving the marriage between the appellant and the respondent. Full stop. Learned counsel representing the respondent did not dispute the fact that the spouses resided together only for a short period of less than 3 months after their marriage in the year 2018. Full stop. However, he vehemently and fervently opposed the submissions advanced by the appellant's counsel, urging that the respondent was maltreated and was unlawfully turned out of the matrimonial home on account of the greed of the appellant and his family members for dowry. Full stop. Learned counsel contended that none of the cases filed by the respondent are barred by limitation, nor can it be said that the allegations leveled by the respondent against the appellant and his family members do not disclose a valid cause of action. Full stop. He submitted that the appellant was granted conditional permission to travel abroad by the family court on 9th May, 2022. Full stop. However, instead of complying with the family court's directions, the appellant failed to appear for subsequent hearings and sent derogatory and threatening emails to the respondent. Full stop. Under these circumstances, the magistrate was fully justified in directing the initiation of extradition proceedings against the appellant. Full stop. Learned counsel thus concluded his submissions, stating that it is not a fit case wherein this court should feel inclined to grant any relief to the appellant by exercising its extraordinary jurisdiction under Articles 136 and 142 of the Constitution of India. Full stop. We have heard the learned counsels appearing for the parties and have given our thoughtful consideration to the submissions advanced and perused the pleadings. Full stop. Taking note of the facts narrated above, the first question that arises for consideration is whether the initiation of the extradition process against the appellant wide order dated 15th September 2022 is justified in the eyes of the law. Full stop. It is undisputed that the appellant returned to the USA on 19th May, 2018, and his passport was impounded under Section 10 of the Passport Act, 1967, by the concerned authorities on 3rd October, 2018 because of numerous matrimonial and other cases filed against him by the respondent. Full stop. The respondent and her mother-in-law had been residing under the same roof since 2018. Full stop. The mother-in-law had alleged that she was brutally assaulted, and her modesty was outraged by the respondent, compelling her to file complaint case number 446C of 2020 before the learned JMFC, Howrah, under sections 323, 341, 342, 379, 403, 504, 506 and 120 BIPC against the respondent. Full stop. It is further claimed that, despite her old age, she was forced to leave her own home to ensure the safety of her property and dignity from the vicious design of the respondent, full stop. In the aforementioned complaint case, an application was filed by the respondent under section 26 of the DV Act against the appellant, her mother-in-law, and their five other relatives, full stop. A notice was issued to the appellant by order dated 21st July 2022, full stop. Subsequently, on 11th August 2022, the learned JMFC passed an interim order in favor of the respondent, prohibiting her eviction from the matrimonial home and directing the personal appearance of the appellant within bracket respondent therein bracket close and other respondents on the next hearing date, full stop. However, when the matter was listed again, the court noticed that the appellant had not returned to India, and the concerned authorities were directed to initiate the extradition process against him, full stop. We may observe that as the proceedings under the DV Act are quasi-criminal in nature, thus, there cannot be any justification to require the personal presence of the appellant in these proceedings, full stop.